So it's the beginning of another week here, and I want to talk for a moment about the struggles and, in fact, the persecutions that consumer attorneys and advocates face when they dare to take on the federal government through their front corporations, the banks and institutions that are, in fact, just fronting for the federal government. Now, I want to draw everyone's attention first to the National Mortgage Settlement Complaint. That lawsuit is so important because what it describes in first source detail is the direct and interconnected relationship between the servicers, the banks, Bank of America, Wells, Citi, and others, and the federal government. What that lawsuit does is describe that, in fact, while we may be making mortgage payments to the banks, Bank of America, Wells, Citi, whomever, the real party at interest in those mortgages is, in fact, the federal government through their handmaidens, Fannie, Freddie, VA, and other federal institutions. And what's so important for folks to understand, both before you're in foreclosure and certainly in the face of foreclosure and other litigation, is the fact that when you are fighting mortgages, you are, in fact, fighting the federal government. What I talk about in the video, the 49 state attorney general sellout, is the fact that, as described in that lawsuit, the direct endorsement lender program allowed the banks and institutions to go out and lend with the full faith and credit of the United States government. And they got favorable treatment for doing that. It's another example of the close relationship between corporations and government. One of the key elements of fascism is a blending together of corporations and government. And what you see in the United States of America, in a most exaggerated state, and particularly in the scope of real estate finance and residential real estate finance, is a direct blending together, a fusing together, if you will, of the institution of government and the private corporations that run this country right now. And again, there's no more clear example of that than in residential real estate finance. And what that lawsuit lays out is this fused together relationship, the interconnectedness of the awesome power of the federal government and then cascading its way down into state and local governments into our court system. Because what was happening when these institutions went out and made these loans, going back for decades now, but especially over all of 2000, was the fact that the government gave the purse strings to the banks, and the banks then went out and lent that money. And before the ink even dried on that loan that you took out, that loan had been sold or transferred its way up to the federal government, and the federal government retained the primary interest in that. The interests that were retained by the servicers after that loan was sold were not necessarily ownership interest in that loan anymore. They retained, in most cases, only the ability to service or collect the payments on that loan, for which they received princely sums along the way. Now, that relationship works out just fine as long as homeowners are just making those payments in. The servicers are more than happy to accept your monthly mortgage payments and throw that into the servicer's pot. And the GSEs, the government-sponsored entities, Fannie and Freddie and VA and others, are more than happy to take the money from the servicers from each month's worth of America's mortgage payments and then distribute that wherever it goes to pay for wars or Social Security or whatever else those payments go to. But where things really begin to break down and where we feel the crushing boot of the federal government is when perhaps we're in foreclosure, or in more dramatic examples, when the banks and institutions decide to kick down people's doors, drill out locks, and inspect the property that is in fact owned by the federal government. Now, why this is so important is we all need to understand that when we are litigating against these institutions, these banks, we are not just litigating against the banks and institutions. Again, they are essentially just the front organizations that are being pushed from behind by the federal government, who are demanding in many cases that the servicers do their dirty work. Now, one of the key checks in our country against the overreaches of corporations and institutions, but again, initially, the key checks against the overreaching by the awesome power of the federal government had been an independent and a strong judiciary. It's important to keep in mind that when this country was established, our founding forefathers established a third and independent judicial branch. And the primary considerations that our founding forefathers were keeping in mind were attempts to protect normal everyday citizens from the abuses of the federal government. And so threaded throughout our Constitution, the Bill of Rights, early case law, and statutory law that came out of Congress and our government, both at the federal and in the state level, were very specific attempts by our founding forefathers to protect us from overreaches by all of the institutions of government. Now, where this has become very particularly perverted is now that the corporations, again, have become fused together with the agencies and institutions of the federal government. The argument is made that those protections against, for instance, due process or the protections against unreasonable searches and seizures, which apply especially to federal action, and therefore the corporation should be exempted from the application of those concepts that protect us from the federal government. But there is an attenuated relationship, again, as the GSEs and these corporations, which are now fused together with the federal government, we should be protected in the same way against those fused together, those amalgams, those Frankenstein corporations and federal entities that they operate under. We should operate with the same protections as if we were being targeted directly by the federal government. Now, there really wouldn't be much argument, but that if an agency, a direct agency of the federal government, kicked down my door or came trashing into my office, that I would have an action against the federal government. The question becomes, when a front organization is being used to pursue the desires of the federal government, when a front organization, a bank or an entity is being used to carry out and fulfill the directives of the federal government through its sub-entities and the GSEs, Fannie and Freddie and VA, should not that front organization be subject to the same prescriptions and restrictions that the government itself would face? Should not I, as a citizen, when faced with the blunt club that the entities use, not have the same protections that I would if I were in fact being attacked directly by the federal government? I assert that we should. But the fact of the matter is that in this very desperate times that we in this nation and as individual citizens find ourselves in, we do not have those same protections. And this is one of the dangerous creeping influences of the fascist state. It's the fact that the banks and institutions operating both with the full faith and credit of the federal government and then with all of the power of the government institutions, unfettered as they are, as private corporations they assert to be, they have the best of all worlds. They have all of the power and all of the awesome resources of the federal government, and yet they are unrestrained because they have all of the freedoms of private corporations. Now, if you're an attorney that just sort of goes along with the flow and processes modifications and doesn't really push these issues too much, you probably won't find too much resistance. You probably won't find the kind of pressures that you find when you start scratching a little bit too close to these things. And specifically what I'm talking about is, you can go about your legal career fighting in state court and elsewhere and not really face persecutions as long as you go along. But the moment you start pushing on issues and really doing your job as an attorney, which is to advocate aggressively for consumers and the rights of people, and to take your oath of admission seriously, that you will fight as if that were your own fight, and respect both the rights of litigants, but keeping preeminent the laws and the Constitution that we again took an oath to uphold. The moment you start to do that, you find yourself the target of very real persecutions and abuse, both by the court system directly, the litigants involved, and other parties. I'm speaking specifically about the threats of sanction motions that attorneys and advocates who fight hard for consumers always find themselves the target of. When you start pushing hard and when you start pursuing the kind of theories that I'm talking about here, which are very real and brought in good faith, You find yourself the target of bar complaints. You find yourself the target of sanction motions. You find yourself the target of lawsuits and other litigation. And you find yourself the target of other threats that come in underneath the radar and in different areas. Now, any attorney worth their salt who has indeed been standing up and fighting for consumers is going to be able to describe where he or she has felt and in fact experienced in very explicit and direct terms each of the things that I've just described to you. And what we have to understand as Americans is that if these attorneys that are out there on the front line fighting for consumers are able to tell you that they feel the very real threats and persecutions, then we as American citizens need to take very seriously those threats and persecutions. You know, where this becomes particularly dramatic is when you as a litigant, when you as an attorney are in a courtroom squaring off against a bank or an institution in particular, and on the other side of the courtroom, on the other side of that desk, you find yourself aligned against gangs of attorneys, teams of attorneys, whole platoons of attorneys coming at you, not just at one at a time, but all together, all at once, and pounding on you. $600 an hour, $700 an hour, thousands of dollars an hour that the entire team are aligned against you to fight with you. That's an unfair battle under any circumstances. But the construct of our court system, the delusion that we live under, is that our court system should seek to balance those interests such that any litigant can come before the court throwing itself on the mercy of the court and expecting to find some sort of balance between the awesome power of the federal government and its fighters, the corporations that it stands before. But that, in fact, is not the case. And so when you, as an individual advocate, and when attorneys, consumer advocates, go in front of the court system, trying desperately to uphold those laws that I see behind you, trying desperately to fight for the principles that are embodied in the Constitution and the Bill of Rights, such that no consumer, such that no American should feel victimized, such that no consumers, no American should feel threatened or abused when he comes before the court system in good faith to fight for justice and liberty and in the rights of all. That, in fact, is not the case. When you do come before the court system, the threats that consumer attorneys and individuals face because they dare to stand up and challenge the overreaching of the corporations and the federal government is very real. It's something we've all got to keep in mind, and we've got to plead to the judiciary to take a step back from the position they find themselves on, sitting in these benches with those black robes. We have to ask our judicial system and the members of the judiciary to take very seriously that oath and to understand the responsibility, that sacred, that solemn, that critical responsibility that in the function they serve to protect the individual's liberties. It's a daunting task, to be sure, because, you know, when the judge reads the pleadings and the arguments made by the banks and institutions lined up on the other side, they are in fact well-crafted arguments. There can be no argument about that, and there's no question but that those litigators, those attorneys on the other side are in fact the brightest, the most well-resourced opponents in the world right now. And it's easy to be that polished and that sophisticated and in fact that good when you are supported at $600 an hour. And when you have support staff back in the offices that are supported in these incredibly lush and sophisticated environments. But what's important to keep in mind is that all of those institutions, all of those law firms, all of that support staff, particularly in the space of this residential mortgage foreclosure and real estate finance, are supported by and directly provisioned by the federal government through the government-sponsored entities and through the hundreds of millions of dollars and, in fact, billions of dollars that they have extracted from the federal government. And so as we fight these battles, we're fighting not just the banks and institutions with their own resources. The banks and institutions and their lawyers are like mercenary armies that have been outfitted and provisioned with our money, with federal taxpayer dollars. And indeed, it's the job of the federal government, and particularly the job of the federal bench and down into our state benches and judges, to understand that they have an important balance to strike. They must strike that balance between the overreaching, the incredible resources of the banks and institutions, and that individual that stands before them. I've had occasion recently to go back and study some of the more important cases of our time, those lawsuits that are seared into our American understanding. And I think particularly of the case of Miranda versus State. Of course, we all know the Miranda warning. It's important to keep in mind that Miranda was in fact a pro se litigant, a pauper, whose attorney, a public defender, abandoned him before his case was brought before the United States Supreme Court. Now, the American Civil Liberties Union subsequently picked that case up, but the point to be made from that particular example is the fact that that litigant was brought before the United States Supreme Court having no resources at all. But that case is seared into American jurisprudence because the judicial branch, the Supreme Court, had the foresight to understand the import of his case. Likewise, Roe versus Wade, that was another case where a litigant came before the United States Supreme Court without the resources that would be found in other cases or other parties. But in this current day and age where the resources and the litigants that come before the United States Supreme Court, or the state Supreme Courts, and in fact any appellate court, the litigants that come before these courts are grossly outmaneuvered, grossly outpowered by the banks and institutions that they're fighting against. But it's important that we in the judicial branch, as lawyers, as officers of the court, and judges in particular, keep in mind that focus, that awesome balance that must be struck between individuals and the corporations that are torturing, in fact, torturing individuals all across this country.